for Justice to discuss measures to safeguard and protect children in sensitive family law cases. Mr. Rabbitte, this falls to you today.
Thank you, Cheann Comhairle. I am particularly thankful for having an opportunity to raise this particular issue again, an issue with which we as public representatives are all familiar. And I was somewhat at sea on the last occasion because I didn't have as much information as I would have liked and like to present to the House. Since then I did some research and I was astounded at some of the things that I found. It was suggested to me that perhaps there was a development of an anti-women element in the courts, and that women weren't getting the rights as a mother, as in the case that I mentioned previously, a mother of children who has particular rights in terms of the primary carer and custodian of the children, and rights under guardian ad litem, and that these weren't observed and were dismissed or were rejected by the court. And subsequently, as it happened in this particular case, the children were accosted by the Gardaí on foot of an order from the courts in school and were brought to the other side, to the respondent in the court case, which was obviously the divorce courts, where the children were taken away from the mother and placed in the custody of the former spouse of the litigant. And again, I said, I concluded, as you would conclude, Cheann Comhairle, having dealt with these things and other members as well for many, many years, that there must be something there that we didn't observe. And I did some more research, and I then discovered that the mother was accused of attempting to turn the children against the father, who had been removed from the house some years previously on foot of a serious issue. And that case persisted to the extent that the mother was warned that if she approached a public representative or TUSLA or anybody else to plead her case, that there would be recriminations for which she would pay in the short and long term. So it would appear now that her offence is that she is accused of, by an accuser, supported by the court, that she was trying to turn the family against the father. But the most important thing is that that allegation was never challenged. The judge in question decided not to hear it. The case went against her, and it is now, since last May, she has not had an occasion to meet her children except by way of telephone call. And repeated admonitions from the solicitor from the other side, pointing out that if she persisted in this, this would be taken into account against her. I did some other research, Cheann Comhairle, you'll be interested in this as well. I researched a number of cases that I had dealt with over the years, and I found that there was a pattern which appeared to be misogynistic, which appeared to address what was referred to as the women's issue, whereby women were seen to be too powerful and were getting too much of their way in the courts, and that this was to redress this. Well, everybody's entitled to their day in court and entitled to due process and natural justice. Mightn't always win, but there has to be an opportunity where the questions are asked by the opposing side and questioned quite strongly in order to ascertain whether or not, this case, to verify the case. And the last point I want to make is simply this. That's their right. It is also their right to have an alternative, a court-appointed child psychologist or psychologist or messenger of the court, as it may be, to deal with the issue if necessary in order that justice prevails. So that's the information I have so far. Cheann Comhairle, you will be interested in the next piece of information that I won't have for another week.
Can I just say before I call it Mr. Rabbitte that we heard some of this case, I think last week, when Minister Roderick O'Gorman was here to deal with it from the point of view of the Department of Children. And I thought long and hard about whether or not we would select this issue today. But I have selected it because nobody is identifiable and because I think, Deputy, you demonstrated over a very considerable period of time your deep concern about this. And I think it raises fundamental issues of natural justice. And therefore, I think it's not something that, I don't know where else it could be ventilated if it can't be ventilated here. So in that context, we're dealing with it again today. Minister Rabbitte, you're very welcome.
And thank you very much, Cheann Comhairle, for bringing me into the picture and the context of this. And I'm taking this on behalf of both Minister McEntee and Minister O'Gorman. So I'm going to keep to the script on this so as we can continue on the story of it, okay? So I'd like to thank Deputy Durkan for raising this important matter here today and for giving me the opportunity to provide clarity on some issues. Management of the court's operational matters and logistical functions are the responsibility of the Judiciary and the court services, which are independent in exercising their functions under the Court Services Act 1998 and given the separation of powers in the Constitution. As such, I am unable to comment on specific matters raised by the Deputy. Section 47 of the Family Law Act 1995 provides that the Circuit Court or High Court may order a report in writing on any question affecting the welfare of a party to family law proceedings or any other person to whom they relate. Section 3 of the Guardianship of Infants Act 1964 provides that the best interests of the child shall be paramount consideration for the court in any proceedings where guardianship, custody or upbringing of or access to a child is in question. Section 32(1) of the 1964 Act provides that in such proceedings the court may do either or both of the following: give directions for the purpose of procuring a written report from an expert or any question affecting the welfare of the child, or B, appoint an expert to determine and convey the child's views. Assessors and experts in family law proceedings are formally appointed by the court and in answering to the presiding judge in a specific case. Minister McEntee is determined to overhaul the operation of the family justice system to ensure that we have a more efficient and user-friendly family court system that puts the family at the centre of its work. This is a key commitment in the Minister McEntee's Justice Plan 2022. The programme for government contains a commitment to enact a family court bill to create a new dedicated family court within the existing court structure and provide for court procedures that support a faster and less adversarial resolution of disputes. The purpose of the legislation is the establishment of a dedicated family court to improve levels of judicial expertise and training in family law matters and streamline family law proceedings, thereby making them more user-friendly and less costly. The general scheme of the Family Court Bill has been referred to the Office of Parliamentary Counsel, and drafting is progressing with a view to publication of the bill as soon as possible in this Dáil session. Minister McEntee also established a Family Justice Oversight Group to develop the first national strategy for the reform of the family justice system and to support the legislative changes proposed in the planned Family Court Bill. The focus of the group is to drive and to coordinate the modernisation of the family justice system to make it more user-friendly, streamlined, supportive and, where possible, less adversarial. The terms of reference of the group include developing a high-level vision and medium and long-term objectives for the development of an effective national family justice system. This will be most obvious in the development of the first family justice strategy and its subsequent implementation. The strategy is currently being finalised. As part of its work to develop the strategy, the group engaged in a consultation process where relevant stakeholders, the public, children and young people who engage with the family justice system gave their views on how a modernised family justice system should look. A number of common issues were raised and are being considered for inclusion in the emergent family justice strategy, including a greater focus on children, the availability of and access to support services, the potential use of less adversarial approaches to the resolution of disputes, and, where possible, an appropriate training, information and dissemination and awareness training. One of the areas being considered by the group is additional training for those working within the family justice system that would benefit all of those who engage within the system. The Family Court Bill will provide that specialist knowledge, and ongoing professional training in the area of family law will be required to be appointed as a family court judge.
Thank you. Deputy Durkan.
Minister for State for coming into the House and to addressing the issue very comprehensively, and it is something that certainly falls into the area of a change in legislation. And as we know, we referred to the in-camera rules as they apply to family law cases, and like you and other members of the House, I in the past have had to go into court as a witness in such cases. Mind you, not everybody welcomed me with open arms, but I did what I felt I had to do. But the point about it is this: is that fair play, they say, is good sport, and wherever it applies. And the Minister for State has just mentioned one thing: the rights of the child and protection of the rights of the child, and consultation with the child in particular situations, which didn't take place except in an arbitrary fashion by somebody who proclaimed to know best what to do. And that is something that most mothers in the country will have strong objections to, and I don't blame them. But the point that I made as well in relation to the pattern, I'm worried about the pattern, Cheann Comhairle, of a number of cases that I dealt with, whereby there was an attempt to take away the rights of the mother of children, or to take away her rights that she might have after rearing her family and suddenly facing the possibility of being out on the road after 20 or 30 years. That cannot and should not happen in any democratic society. And certainly all the members that I know in this House have always dedicated themselves towards getting fair play for people in such circumstances. So in conclusion, I'll just say this, that I hope and incidentally, the question was down to the two ministers, and both departments have been threatened obliquely by the other side as to there being consequences in the event of a report being made to either or both of them. So I hope that we have addressed the issue, and I hope that there will be action taken to ensure that the issues that I've referred to are addressed and addressed fairly by the courts.
Thank you, Deputy Minister.
Chair. And on behalf of Minister McEntee, again, I would like to thank Deputy Durkan for raising this matter here today. In addition to the progress previously outlined, Minister McEntee recently held a public consultation on the topic of parental alienation, which provided a valuable opportunity for stakeholders and citizens to express their views on this complex issue and inform her department's thinking on whether any legislative and policy changes may be required. All views, opinions and experiences submitted as part of this consultation have been welcomed. Those responses received are currently under review, and the Department of Justice has arranged for a separate strand of independent research on parental alienation to be carried out last year. Minister McEntee is pleased to say that a draft report has been received by the Department of Justice and is now being reviewed. And it is expected that both the research and the public consultation will create a deeper understanding on the issue and inform the Department's consideration on policy and law in this issue. And Minister McEntee expects the report outlining the outcome of the research and consultation process and any arising recommendations towards the end of the year. And I think, Deputy, what you have said there in relation to the voice of the child, we had a referendum on it, and the voice of the child has at all times to be taken into consideration. And I'm delighted to say that my colleague, Minister McEntee, has this work done in relation to parental alienation, while today you talk about the mother. In a lot of cases too, it is the experience of the father as well, who finds themselves in that similar position. So we actually have to have the child at the centre and stop weaponising one parent against each other to ensure that they can come down heavy on one side or the other. So I do welcome what Minister McEntee is doing, and I will relay your comments to her. Thank you.
Thank you very much, Minister. And thank you, Deputy. We move now to Deputy John Hart, please.